Hello everybody, welcome to the third session that I'm recording to upload for you. This is my third video. The first two were on British Constitution and this third one is on constitutional conventions. Alright, so the handout that you will require for you to have with you to help you with your revision would be the first handout, because that has got 3 topics in it, which is British Constitution, conventions, and separation of powers. So you need to turn to page 10. All right, I repeat, you need to turn to page 10 of that first handout. Okay, now before we start, just so that we remember the mantra, I'm going to try to do it for every class just as a motivation for us through these trying times. Thank you once again for staying with us and for tuning in. All right, so here we are. Right, I think I can, I think I can, I think I can, I know I can. Right, as I said, that helps me as well, because I'm turning into a zombie here, talking to myself every day. Okay, right, let's go straight into the question, because I've really told myself, okay, that the video must be shorter, because it just takes hours to upload if the video is long, huh? So I'll try and do it as fast as I can today. Okay, if you look at page 10, you look at that question, 2017 Zone A, question 2. That's quite a challenging question, so I thought we'll start with that. And that is a quotation by Sir Ivor Jennings. Okay, let me just read it to you. Conventions are obeyed because of the political difficulties which follow if they are not. I repeat, conventions are obeyed because of the political difficulties which follow if they are not. That means that, what is the Ivor Jennings saying? That means that people follow conventions, they are obeyed, because if you don't follow it, political difficulties will follow. All right? Now, is that true? My answer will argue that to a large extent, this is indeed true. All right, so to a large extent, this is indeed true, that conventions are obeyed because of the political difficulties or consequences that follow if they are breached. And this answer will give examples to substantiate that, and I will go through the answer structure in a minute. All right. However, in order not to be over simplistic, I will also argue that there are other reasons why conventions are obeyed. So yes, political difficulties is definitely a very important thing, but there are also other reasons why conventions are obeyed, and the special place that they play in the British Constitution itself. All right, so if you look at that answer, I've broken it down into several heads. If you could keep it open on page 10. First, respond to the question. Second, what's the nature of the Constitution itself? Third, give some examples, all right, of constitutional conventions relating to the 3 organs of government. Fourth, go straight into the question, which is, okay, why are conventions obeyed? Fifth, what are some of the political difficulties that follow a breach of conventions? Because this is where the meat of your answer should be. All right, the political difficulties that follow breaches of conventions. Now here, if you turn to page 11, I have actually divided my answer and I've given 7 examples of breaches of conventions and what has happened as a result. All right. So now in 45 minutes, maybe you may not be able to write or make reference to all those 7 examples, but perhaps at least if you make reference to 4 or 5, you should be all right. Okay, so I've got 7 examples of conventions and what happens if you breach, what are the political difficulties, all right? And then once I've done that, at the end of my answer, if you turn to page 13, I then go on to the last part, which is to talk about, okay, since we're talking about obeying conventions, would codification help, all right, with making people obey conventions more? And last, so arguments for and against, and lastly, my conclusion. So that means that there are actually how many parts to this, all right? If you go back, respond to the question that's I've labeled that as number 1, number 2, nature of the British Constitution, number 3, all right? So if you have a pen and, the handout with you, we can do this in a interactive way as well if you want, right? So number 1, respond to the question. Number 2, nature of the Constitution. Number 3, give examples of conventions. Number 4, you see that bullet point, why are conventions obeyed? Number 5, bottom of page 10, political difficulties which follow. Number 6, examples of those number 5, political difficulties, and then that's already numbered, isn't it? So you've got 1 to 7 case studies, all right? And then last part on page 13, number 6, would codification make people more likely to obey them? Arguments for and against, and number 7, conclusion. So again, I've ended up with 6 or 7 bits to my answer, which seems to be roughly what I'm doing for most of my answers, all right? So come back now to page 10, please. Is everybody with me? Everybody all right? Yeah? Okay. Feel free to bring a cup of coffee or tea. I've got a cup of tea myself to keep me going. Yeah? So have a look at that question again. Yeah? Read it to yourself. Right. So, firstly, responding to the question, so is it true conventions are obeyed because of the political difficulties which follow if they are not? My answer is yes, that is largely true. So, this answer will argue that it is indeed largely true that they are obeyed because of political difficulties which follow if they are not. However, there are also other reasons why they are obeyed, which I will discuss under part 4, further down page 10. Okay, right. So once I've done that, number 2, I come to the nature of the British Constitution itself, the second bullet point. So describe the Constitution, its sources, the fact that much of it is largely unwritten, non-legal, right? And how constitutional conventions play such an important role in that, yeah? And then the third part, give some examples of those constitutional conventions, right? Now, what could some of those examples be? The Convention of Royal Assent, that if a bill passes through the House of Commons and the House of Lords, that the Queen should give assent to that. The Convention of the appointment of the Prime Minister, the Convention that the Prime Minister must be a member of the House of Commons, the Convention of Ministerial Responsibility, that Parliament must be accountable collectively and ministers must be accountable individually, and how, you know, this is obeyed really, we'll come to that later, but this is obeyed really so that we have the principle of democratic transparency and accountability in a nation, how important that is, yeah? All right, and then other examples, yes, that the House of Lords, being unelected, must eventually bow down to the supreme will of the House of Commons, especially if, you know, they're going to enact something which has already been promised to the public. And then the Convention of Independence of the Judiciary, the Convention that the judiciary should not criticize the executive and vice versa. The monarchy itself must be neutral, okay? And then conventions that have developed in the last 2 decades, for example, the Sewell Convention. Now, the Sewell Convention, named after Lord Sewell, is very, very important because of the devolution process that has started from 1998, and that's been an ongoing journey in a sense, all right? why I say the Sewell Convention is so important is because the convention itself is that Westminster Parliament, will not normally legislate for the devolved administrations unless those devolved parliaments give their consent. All right, so that's the convention. But later we will come and see, in the case of Miller number 1, what the Supreme Court actually said about that convention. And we will see how we can use that information for this question. All right, I'll come to that later. So you're then finished with part 3, which is you've given some examples of conventions. Then you come to the meat of the answer. All right, don't spend too long on introductory matters. You don't have time. All right, so the fourth part is, all right, so why are conventions actually obeyed? Now, before I go to political difficulties, if you look there, I have said, the first point is I've said that they are obeyed because they are actually beneficial for the Constitution. You might want to add a reminder there that they are obeyed. Why? Because they are a very important, a vital source of the Constitution. They are a non-legal source of the Constitution. That's why they are obeyed, because people feel that they are important. Marshall and Moody defined conventions as what? Political rules, binding on those who operate the Constitution. All right? Recognized by the courts, but not enforced by the courts. So they are obeyed because people feel that they need to obey them, that they are an important source of the Constitution. All right? And if you look at the other reasons, that they are obeyed to create stability in the system, a sense of order in the system. They are obeyed because they are a means to control discretionary power. So that's very important. And they are also obeyed because members of government feel that it lubricates the machinery of government. There are many conventions, like ministerial responsibility, are flexible. So they are obeyed as well, because it actually helps the government to stay in office as well. Later when we come to the convention of collective ministerial responsibility, why is that obeyed? So that people will have confidence in the government. Look at us now, all sitting at home, and every few days tuning in to watch our Prime Minister, Muhyiddin, telling us what to do in the CMO. Do you see any of his other ministers arguing or saying anything about that? No, right? Everybody must show a sense of unity. Why? Do you think everybody necessarily agrees with everything that the Prime Minister might say? Not true. Just like in the UK. So Boris Johnson might have said, with regard to COVID, right? You will know that until today, there is no curfew or lockdown in the UK, as in to say that nobody can even leave their house, let's say. There is restricted movement guidelines. Okay? Some people are saying that they should have that, right? Many people disagree with what Boris Johnson is doing or not doing, as the case may be, right? For example, Boris Johnson has told his ministers that he's not going to join the EU to buy more ventilators for the UK. Many of his ministers are angry with him. But do you see anything where the ministers have come out in the open in his cabinet and attacked him now during the COVID pandemic? No, right? Why? So why is collective ministerial responsibility obeyed at the moment with regard to the COVID for COVID pandemic for Boris Johnson? Why? It's obeyed because it needs to be followed to create stability in the government, to create a sense of unity in the government, so that the public don't panic. So these are reasons why conventions are obeyed, okay? Not just because of political difficulties. There are other reasons. Now, once I've said that, and if you look at page 10, I've also said, when I talk about control of discretionary power, I've also mentioned the phrase checks and balances. Now, what do I mean here? That means that conventions are also obeyed because conventions form a way as a checks and balance in the UK Constitution itself. So for example, before the Constitutional Reform Act of 2005, the Lord Chancellor was stepping into, stepping into all three of the different organs of the Constitution. So what was the checks and balance? Conventions, to make sure that there was no abuse of power. So these are all very important reasons why conventions are followed. All right? Okay? Now, once I've said that to the examiner, I then come on to the political uncertainties or the political difficulties part, because that's an interesting part, isn't it? And if you look at page 10, once I've talked about all that, 3/4 of the way down, if you look right, I've put that political difficulties that may otherwise follow in the event of breach. So I'm linking it back to the question. Remember what we've always said, whatever you're saying, you need to make it relevant for the question. So that means I've put there, remember to link back whatever you're saying to the question. So conventions are obeyed for all those reasons that we said just now, but they are also obeyed largely because of, look at the next line there, the fifth part of your answer, I've put it in bold. Because of what? Because of the political difficulties that follow if you breach them. So the next part of my answer is going to be about political difficulties if conventions are breached. Political difficulties. So bottom of page 10, is it true, I've asked this question, is it true that political difficulties would ensue if conventions are breached? Is it true? All right, now what's the answer to that? The answer is yes. Write it down there at the side there in case you forget. Yes, to a large extent, this is true. Now, let's pause a minute and think about what we just said. Okay, I'm going to repeat it to emphasize. Yeah. So, what I said just now, is it true that political difficulties would follow if they are breached, if conventions are breached? And I said yes. Now, this is what you need to understand. You must, if I'm saying yes, I now need to go and give examples of those political difficulties that have followed a breach of convention. So turn to page 11. So I now go to examples of political difficulties. Now, what are some examples? The first example is the clash between the House of Lords and the House of Commons in 1908 to 1910. Now, so that's my heading, the clash between the HOL and the HOC. What happened here? What was the convention that was breached? The convention that was breached was that if the House of Commons wants to pass legislation, and especially if it's a money bill or anything related to finance, the House of Lords should not block that. The House of Lords should allow that. However, in 1908 to 1910, with the new government, and they wanted to come up with a new bill on the budget, on finance issues, which the House of Lords didn't like, and they tried to block it. All right. So by doing that, they had violated the convention. Now, what happens next? There was chaos. Political difficulties followed. All right, there was chaos after that. The Prime Minister was not sure what to do. He wasn't sure whether he had to speak to the King to create new peers and put them in the House of Lords. There was a stalemate between the House of Commons and the House of Lords. This is what we mean by political difficulties. It was a constitutional crisis. And as a result of that, the Parliament Acts of 1911 and 1949 were eventually passed to reduce the House of Lords' powers so that they could no longer block legislation, to reduce their powers, to give them a maximum delaying power. If it's a money bill, maximum 30 days. If it's a non-money bill, maximum 1 year. So what does this example show? It shows that if the convention was breached, political difficulties followed. Second example, the Salisbury Convention. Now, what is the Salisbury Convention? The Salisbury Convention says that if any particular government has promised in their electoral manifesto that they would come up with a particular bill or legislation, then the House of Lords should not block it, because this is what the people want. Now, what happens if the House of Lords does block something which is in the electoral manifesto? What will happen? There will be political difficulties because it will go against democratic principles. So that's another example. The third example is, I'm going to discuss the case of an amendment of the Constitution of Canada. Now, what happened in that case? That case concerned a convention. Well, first of all, that case happened in Canada, all right? So I know that why should that be relevant? We're looking at the UK Constitution, but it's a Supreme Court of Canada decision. It's a Commonwealth case. So therefore, it's of high persuasive authority in the UK. Now, what happened here was that in Canada, the convention was that if the federal Constitution of Canada was going to be amended, the convention required the different states in Canada to be consulted before that amendment took place. What happened was that the government went on to undertake that amendment to the Constitution without consulting two states, right? Manitoba and Quebec. So the convention says you must consult the states before the amendment, but you don't consult. That means you have violated the convention, right? So what happened? Political difficulties happened. There was an uproar. Some of the states that, the states that were not consulted felt upset. It'll be, let's say the federal government wants to do something, something major which affects the whole country. They don't consult Sabah and Sarawak. How will they feel? How will they feel? So that means that these states which were not consulted felt isolated and somewhat abandoned. So there was so much of an uproar that a case was brought and it went to the Supreme Court. Now the Supreme Court recognized the convention, all right? The Supreme Court the Supreme Court recognized the convention, but the Supreme Court said there's been a violation, we recognize that, but it's not our job to do anything about it. The amendment would still be valid. Now what happened after that? The government went back, consulted the states, all right, withdrew their amendment, and then after the states had given their consent and were ready, then only they went ahead with that amendment again. So that tells you what? When the convention is broken, political difficulties follow. The states are upset with each other. A crisis, constitutional crisis happens. So that's the third example. The fourth example, Miller number 1. Now, Miller number 1, I know is a prerogative powers question. I beg your pardon, is a prerogative powers case. But in Miller number 1, the Sewell Convention was also discussed. Now, the Sewell Convention, let's remind ourselves again, and if you've got a pen with you, you can write at the side there. The Sewell Convention says what? Okay, let's understand it first. That Westminster Parliament will not normally legislate for any devolved administration without their consent. Okay? Now the thing is this, class, listen carefully. This has already been recorded. So the Sewell Convention is now codified in Section 2 of the Scotland Act of 2016, which amends Section 28 of the Scotland Act of 1998. And it creates a new subsection, Section 28 sub 8, which says that, and I'm going to read it out to you. It says that it is recognized that the Parliament of the UK will not normally, it doesn't just say will not, it says will not normally legislate with regard to devolved matters without the consent of the Scottish Parliament. So the Sewell Convention is recorded. It's codified. I want to ask you one question. So that means that most of the time, why is the Sewell Convention, why is it followed? Why is it followed? It's followed so that Scotland won't feel irritated, isn't it? So it's followed because political difficulties will arise if it's not followed. Am I correct? So it's followed because Westminster Parliament would try to avoid those political difficulties. Am I right? Think about it. However, if you want to make your answer more interesting, what can you say? You can talk about the Miller number 1 case in 2017, and if you look at the bottom of page 11, look at what the Supreme Court, Lord Neuberger, said about the Sewell Convention. We discussed this in class during lectures and tutorials, but I want to reiterate because it's something very important, right? So what did the Supreme Court say? It said that in reaching this conclusion, do not underestimate the importance of constitutional conventions, some of which play a fundamental role in the operation of our constitution. So they recognize the importance of constitutional conventions. They recognize the Sewell Convention. And why is it followed? Look at the next line. Highlight that if you have a highlighter, right? Look. So take a highlighter, highlight that. But, and I'm doing it as well, the Sewell Convention, why is it followed? It has an important role in facilitating harmonious relationships between the UK Parliament and the devolved legislatures. So why is it followed? It's followed in order to create harmonious relationship. What if it's not followed? There will be a loss of harmony. Political difficulties will ensue. But if those political difficulties happen, look at the last line there, but the policing, take your highlighter, but the policing of the scope and the manner of this operation does not lie within the constitutional remit of the judiciary, which is to protect the rule of law. So what are they saying? Conventions are not law. They're political. They're not justiciable. We are not going to enforce them. Right? Now think. So they're not law, right? Okay. But aren't they codified? They're in section 2, right? So that means that what? Sometimes even if a convention is codified, it still may not be enforced in a court. Remember that. So you're sitting there at home thinking, oh, everybody told us that if something is codified, oh, it will be enforced by court. Now the teacher is saying that even though it's codified, it's not enforced. Yep, that's right. I am telling you that. I'm also telling you, if you look at section 2 itself, it's ambiguous, because it says that it is recognized that the Parliament of the UK will not normally legislate with regard to devolved matters. Will not normally. Not normally. What does that mean? Will not normally. That means that if it wants to, it still can. Will not usually. So it's like saying, well, the sky, the tropical sky over Kuala Lumpur will not normally create a hailstorm. Of course, we know that. But can there be a hailstorm? Has there been a hailstorm in the past? Yep, it has happened. So think about that. So that's the 4th example. If you turn to page 12, I've got to speed it a bit. I told myself that I must finish within half an hour because otherwise uploading is so hard. So I'm going to just speed it up a little bit. Now, we come to page 12. So the 5th example is, I've put that, breaching the Convention of Parliamentary Accountability. In other words, I'll do 5 and 6 together. Collective ministerial responsibility, right? Number 5 and 6 is about collective ministerial responsibility. Now, what is collective ministerial responsibility? That, if you look at number 6, it is about what? It is about the Prime Minister and his cabinet following up or projecting. That means the Prime Minister says something and the cabinet agrees with this. It gives a united front, right? And in terms of cabinet secrecy, in terms of cabinet meetings, there is like a little, nucleus within the government, which what they're trying to do is to give that impression of unity, to ensure that the public feel confident in them. Of course, there are some examples of exceptions. There are agreements to differ, all right? Okay, but by and large, why is the convention followed? Because of political difficulties that happens if you don't follow. If I'm a minister in the cabinet and I don't like what my prime minister is saying, and I don't follow it, and I come up and I disagree with him. Let's say, for example, now, I'm in Boris Johnson's cabinet, and let's say I totally disagree with how he's handling the COVID crisis. If I come out and I voice that, I probably will have to resign. All right, Boris Johnson will tell me to, get lost, right? So that means that CMR, collective ministerial responsibility, is followed because of the political difficulties which will happen if they're not followed, if it's not followed. Which brings us nicely to number 5, the Miller number 2 case. Now, Miller number 2 was about prerogative powers, about Boris Johnson proroguing Parliament just before they were expected to initially exit at the end of October. And people were upset. There's a challenge brought, by Miller against the Prime Minister to say that this is an unlawful prorogation. Again, prorogation is a very political matter. It has never been tested in court before. What did the Supreme Court say? What did Lady Hale say? If you look there, this is on the top of page 12, the Supreme Court, sitting as a panel of 11 justices, ruled unanimously that the advice given to the Queen to prorogue Parliament was unlawful and that the issue was justiciable. Now, in my next video on separation of powers, I'm going to come back to that, all right? Because that's really, really a very interesting thing to pursue, and we'll come back to that. And for now, I want you to look at the next paragraph on your page 12, where I talk about what Lady Hale said. 2 fundamental principles underpin the Constitution, she said: parliamentary sovereignty and parliamentary accountability. Parliamentary sovereignty and parliamentary accountability. Now, parliamentary accountability, look at the second one. That's a convention. So what she's saying, Lady Hale said that what? She said that Parliament's sovereignty would be undermined if the executive could prevent Parliament from exercising its legislative authority. On accountability, the longer Parliament was prorogued, the greater the risk that accountable government would be replaced by unaccountable government. Now, what does that mean? What does that mean? She's actually saying that, look, we should allow Parliament to be up and running, because if Parliament is prorogued, ministers are not collectively accountable. Well, ministers, the Prime Minister is not, accountable. There's no collective responsibility. There's no parliamentary accountability to the public. Now, what do you see from that? So what she's saying is that the convention is so important. Go back. Open up Parliament. Do what you're supposed to do. Answer about Brexit. You're supposed to be leaving soon. The public has a right to know. So why is this convention, she's saying, why should it be observed? It's at the heart of democracy. It's at the heart of the principle of the Constitution itself. That's why it needs to be observed. If we don't observe it, we'll have political difficulty. All right? It's also very interesting because what else does it allow us to think? Lady Hale says it's a one-off case. But isn't it an indirect way of enforcing in a court of law, and the Supreme Court as well, parliamentary accountability? Think about that. All right? Isn't she in a way indirectly enforcing this convention of parliamentary accountability? I think she is, I really do. I think she is. She's qualifying it by saying that it's a one-off, but that's what she's doing. So why is this convention of parliamentary accountability? Parliamentary accountability means both collective ministerial responsibility and also individual. That means how ministers are accountable in Parliament. Why is this so important? Because she's saying It is a fundamental principle of the British Constitution. Yeah? So that will be a very nice thing for you to talk about and bring into your answer. Okay? Yeah? Right. And then if you look at the bottom of page 12, the 7th example is individual ministerial responsibility. So really 5, 6, and 7, these case studies could be taken as one, as why ministerial responsibility, whether it's individual or collective, why are they followed? Because if you don't follow it, political difficulty may actually result. Okay? Of course, with individual ministerial responsibility, sometimes people do breach it. Sometimes they resign, sometimes they don't. And there's a great deal of flexibility here. All right? But generally, what Lady Hale is saying in Miller is that parliamentary accountability is so important. It must be followed because it is a fundamental principle which underpins the Constitution. Okay? So very important. The last part of my answer, if you turn to your page 13, is before I finish off my conclusion, I might want to just tell the examiner, well, would people be more likely to obey conventions if they are codified? So I might have a short discussion there on whether codification would result in more people obeying conventions, since the question is about why people obey conventions. Would codification make people more likely to obey the rules? What are some arguments for codification? First, clarification, clarity and certainty. Those are those same arguments, like we said in the British Constitution, that people would be, more aware. They would be clearer as to what are the rules. There might be greater reverence. The meaning of the word unconstitutional might be clearer, and there may be more chance of enforceability. All right? Arguments against codification. Well, what DeSmith says, and Jennings also, all right, that if you codify, you would lose the flexibility. And that's a very important advantage that conventions give. All right? And also the second one, well, conventions allow the Constitution to evolve. And look at the Sewell Convention. It's been codified, but that did not make it, that did not end up making it more enforceable in a court of law, did it? He spoke about that just now. So enforceability doesn't mean that just because you codify, it's going to be enforced. And then some types of conventions are may not be suitable to be codified, especially ministerial responsibility. Yeah, because you need a sense of flexibility with that. How would you categorize what are the situations to resign or not resign? It would be difficult to do, and it may also end up politicizing the judiciary. So these are some examples against codification. All right. Lastly, conclusion. So round up everything and go back to the beginning of your answer. And what we've said is, I would reiterate that this answer has argued that conventions are obeyed for a variety of reasons, but to a large extent, what Sir Ivor Jennings says is very true, that it is, it is true indeed to say that conventions are obeyed, because otherwise political difficulties will follow. So that is certainly largely true, but our answer also explored other reasons why conventions are followed. All right? Okay, so that brings us to the end of that question. I'd like you to also draw your attention to also some of the other questions that have arisen, and if you have a pen there, you might just want to add the 2019 October question, 2019 October question 2, discuss the importance of constitutional conventions to an understanding of the nature and working of UK constitutional law. Nice question there. So, and then I've also given you two other examples at the bottom of page 13. All right, the 2018 and 2016, for you to have a look and have a think. And essentially, if you look at the 2016 question, What's the role played by convention? Is it the most compelling argument in favor of a codified constitution for the UK? That question really is a mixture of British constitution and conventions. So it's asking you to look at what are conventions? Why are they important? All right. Examples of conventions. Okay. Should they be codified? Are conventions the most compelling, means important reason for it to be codified? Or are there other reasons? So whatever we said for British constitution, reasons for codification can all be brought in. All right. So you see here, this is a link between the two topics of British constitution and conventions. Of course, there's a link because conventions are an important source of the non-legal source of the British constitution. Okay, that's brought me to 40 minutes. I really must stop now. So that brings us an end to the topic of conventions. My next video will be on the, I beg your pardon, my next video will be on the topic of separation of powers. Yeah, all right. Thank you for listening, and stay safe. All right, stay happy. Bye-bye now.